This judgment, I can say that it is a watershed moment into the taxation jurisprudence. Yes, it is the watershed moment. But there are two parts of understanding, two or three parts how to understand this judgment here. First, let's understand what was the dispute here. So unless we understand the dispute, then we cannot go onto this part here. Second part is that what was the remedy why the Supreme Court was trying to give. And third part is that what is the why the 142 has been invoked, whether the why Supreme Court has invoked 142. And fourth part is that we can also understand the implication of this judgment here. And I understand there are a lot of queries that will be there on the implication of this judgment here. Before starting my PPT and citing the judgment here, I would like to say that, and let's understand what was the dispute here. The dispute was that after the Finance Act 2020 and before the Finance Act 2021, there was a law which was enacted by the Parliament, and that was the Relaxation Act that we generally called as a TOLA. And through this, a power which has been vested to the assessing officer, that the notices under the old provision of the 147 and 148 can be given within this period and within 3 months or within 3 months or within 3 months, and it was extended there. Last notice was which was dated 31st March 2021. We said that the notices can be given up to 28th April. And after that, there was 30th April. And after that, there was another extension that was given through the notification number 38 of 2021, that it was said that notices can be issued up to 30th June 2021. So, if we start the understanding of this case here, first there was an unamended provision. After that, there was a TOLA. And after that, the new amendment came in and the new provision which came in, and that provision was effective from the 1st of April 2021. With this in TOLA Act, that's a Taxation Relaxation Act, and the notification, and through the explanation of these two notifications, it was said that the notice under 148 can be issued up to 30th June 2021 following the old provision only. And with this, the assessing officer issued the 148 notices following the unamended act, which was valid up to 31st March 2021, post 1st April 2021, up to 30th June 2021. And all these notices were challenged before the High Court. Not all the notices, as we have seen in the judgment, around 90,000 notices were issued, and 9,000 notices were challenged in different high courts, and in different, and around 90, this one's here. After that, the issue arises here. Various high court passed their own judgment, saying that these notices, which had been issued under the old provision of the 148, are not a valid notice, are bad in law. This notice should have been issued under the new provision, because from 1st April 2021, the new provision has come into force. And with this, all the high courts, you can say the Delhi High Court or Chennai High Court or Bangalore or Bombay, every high court has passed the order, except in the case of Chhattisgarh High Court, which gave, first it was a single bench order, which gave in favor of the revenue. However, after that judgment here, it also gave some judgment in favor of the SSC also. All these issues were in the SLP before the Supreme Court. However, in this case, in the case that we will be discussing here, it was the matter from the UP High Court, Allahabad High Court, that traveled to the Supreme Court, and all other SLP were in the pipeline that were not discussed here. So what was the matter before the Supreme Court? The revenue argued that this provision of the 148 is a procedural provision, is a procedural law, and when it is a procedural law, it should go back, it should trace back, and when it will trace back, it was just a mere procedural mistake which the assessing officer has done by issuing the notice under a belief that these notices are valid notice, and therefore this procedural law can be overcome by passing an order here. This was the mainly general crux of the argument was there. How they have got that this provision is a procedure law? Because they got the help from the Delhi High Court judgment here. What the Delhi High Court judgment had said in the para number 62 to 65 here, I'm just trying to read this part, paragraph number 62, 62, 65. Which says that, it was from para number 55 to 67. This Delhi High Court in the Manmohan Kohli has said that this court is in the opinion that new provisions are remedial and benevolent provisions which are made and instead to protect the right and interest of the SSE as well as to promote the public interest. So this para has helped the revenue to articulate their argument before the Supreme Court, saying that this is a procedural provision. In Imperial Tobacco Company versus Attorney General, the object of all the procedure rules is to enable justice to be done between the parties consistently with the public interest. If the procedure rules are defective, the legal apparatus work less efficiently and the public interests suffer. If the legislation is introduced to remedy the defective rule and no one suffers thereby, it is sensible to apply the pending proceedings. Consequently, this court is of the view that the Finance Act 2020 introduced a new regime regarding the procedure to be complied and in respect of the reopening of the income tax assessment, and accordingly, the benefit of the new provision must necessarily be available even in respect of proceeding relating to the past assessment years provided. Of course, Section 148 has been issued. Of course, Section 148 notice has been issued on or after the 1st April 2021. With this point or with this procedural law, the revenue started the argument saying that the procedural law, the defect in the procedural law should not be an impediment, in the substantial law, and therefore it can go back, it can be traces back, and therefore all the notices which has been issued perpetually under old provision of the Income Tax Act can be construed as a new provision, can be construed as a notices under the new provision of the Act. So this was the first argument which was taken by the revenue in this part here. Second issue which was there, which is also important to understand by the judgment of this here itself, why the court is saying that it is a benevolent provision. I'm just going to the para number 6 of the judgment. If I can, for the sake of understanding, I can show it in the screen here. Just hold on, sir. Yes. What was written in the para number 6 is very much important, sir, because it sets that tone for the judgment here. It says that it cannot be disputed that by substitution of Section 147 to 150 of the Income Tax, 151 of the Income Tax Act by the Finance Act, a radical and reformative change has made governing the procedure for the assessment proceedings. So it is talking that it is a procedure law only it is a procedure law, amended section 147 to 149 and to section 151 of the IT Act prescribe the procedure governing initiation of reassessment proceedings. However, for several reasons, the same gave rise to the numerous litigations reopening were challenged inter alia on the grounds of no valid reason to believe, no tangible raw material, and everything they have come into this one. And after that, they have discussed the GK and drive start. The discussion of the GK and drive start is very much important here. When it was the Supreme Court through the GK and drive start in the ITR 259 ITR 19 has given the element of the natural justice while doing the 148 assessment here. Supreme Court has stated that after filing of after getting the notice of 148, the SSC should have been authorized, or the SSC can file the ITR, and SSC should file the ITR. After that, it can ask for the reason to believe. The reason to believe should be supplied to the SSC. The SSC can file the objection against this reason to believe on the judicially. The assessing officer should dispose of the reason to believe by way of passing a speaking order. And this speaking order can also be challenged. The reason to believe can also be challenged on the jurisdictional issue. So these were the GK and drive start principle that was inbuilt into the 148. And what has come into the subsequent amendment here, only the GK and drive start, which was the judicial pronouncement by the Supreme Court, has come into a legislative amendment here. And by this, all the provision of all the natural justice point which was there into the GK and drive start has come by way of legislative provision through the 148A. So therefore, it has been stated that it was a procedural in nature. When the law is procedural in nature, what is the implication of this point here? For this purpose, I was trying to go through the commentary which was there by Justice A.K. Patnaik, and how he writes that what is the implication of the procedural law, and how to understand the procedural law also. It says that whether the procedural law can be retrospective, the answer is yes. If the procedural law is retrospective, therefore, how to implement this procedural law, we will discuss this part here. I'm just reading few lines of the book from the statutory interpretation by Justice G.P. Singh here, which talks about a statute dealing with the procedures. It says that in contrast to the statute dealing with the substantive right, a statute dealing with the merely matter of procedure are presumed to be retrospective, unless such a construction is textually inadmissible. As per the Lord Denning, the rule is that an act of parliament is not to be given retrospective effect, applies only to the statute which affect vested right. So the only substantial right can be prospective, but the procedural law can be retrospective also. It does not apply to the statute which only altered the form of procedure or administrative of the evidence or the effect which the court gives to an evidence. It is a new act. If the new act affects the matter of procedure only, then prima facie it applies to all action pending as well as of the future. So therefore, we can say that the amendment which was done, it was a procedural part here. And since amendment was done, it is a procedural part. The Supreme Court has tried that it can be rectified, and therefore Supreme Court has stated that the revenue cannot be a remedialess. Before going to the part here on the remedialess issue, we will discuss the other part here also. Let's see how the Supreme Court is saying that Supreme Court is analyzing the provision of old 147 and new 147. Para number 6.1. Further, it compares the for the pre-finance 2021, the reopening was permissible of a maximum period of 6 years, and in some cases beyond 6 years, leading to uncertainty and considerable time. Therefore, Parliament thought it fit to amend the Income Tax Act to simplify the administration, ease compliance, and reduce litigation. Therefore, with a view to achieve the set objective by the Finance Act 2019, Section 147 and 149 of the Section 151 has been substituted. So these are the coming from the memorandum also, that these were why the amendment was made also. Now coming to the other part here, so para 6.2, which is also critical here. What the para 6.2 says here, why it is say that under the substituted provision of the IT Act, White Finance Act 2020, no notice under 148 can be issued without following the procedure prescribed under 148A of the Act. Along with the notice under 148 of the Act, the assessing officer is required to serve an order passed under 148 of the IT Act, Section 148 IT of the new provision, which is the nature of condition precedent. Introduction of Section 148 of the IT Act can thus be said to be game changer, with an aim to achieve the ultimate objective of simplifying the tax administration, age compliance, and reduce litigation. So, Supreme Court say the purpose of the Section 148 was that it was just codifying the law of the GK and Drives Act. What was stated in the GK and Drives Act, what was their unlegislative law, now it has been codified into the provision of the 148A, and so therefore the purpose of the 148 was that to reduce the compliance and to reduce the litigation. And again, para 6.4 is also important, which says that, let's go to the 6.4 also. 6.4 is not there. I'm coming to the para number 7 also, which is saying that how the provision was a remedial and benevolent here. In the para 7, it says that there's the new provision substituted by the Finance Act being remedial and benevolent in nature and substituted with the specific aim and object to protect the right and interest of the assessee, as well as the same being the public interest. The respective High Court have rightly held that the benefit of the new provision shall be made available even in respect of the proceeding relating to the past assessment year, provided Section 148 notice has been issued after 1st April 2021. So first, it is upholding the judgment of all the High Courts here. So we should not understand that the judgment has been reversed. We should not understand the High Court judgment has been reversed. We should understand the Supreme Court has tried to find a leeway to give to saying that not to make the revenue remedialess. What is happening in this judgment? All the High Court has said that this notice is not a bad notice, and the revenue can do as per the law. But what the revenue has to do as per the law, on that point it is silent. So there was a vacuum which was created, and therefore the Supreme Court has tried to say that, look, the revenue cannot be, the reassessment cannot be in the vacuum. The assessment proceeding has to be there, and the revenue, since it is for the larger public interest, the revenue cannot be remedialess, and therefore they have tried to convert this notice or deem this notice under 148AB. So the first point that I am trying to say, since it is a procedure law, which we have to understand here, we are in complete agreement with the view taken by the various High Court in holding so. So the last line of this para number 7 is completely upholds all the judgments of the High Court here. Now, after that, para number 8 is very critical, and let us understand the para number. So till then here, the Supreme Court is in sync with the High Court. After that, in the para number 8, the deviation takes place, and let's see how the deviation takes place here. I have just, for the understanding or for the benefit of all, I have just pointed out, but I will read from here what is there. However, at the same time, the judgment of the Civil High Court would result no assessment proceeding at all, even if the same is permissible under the Finance Act 2021 and as per the Substituted Act 147 to 151. So therefore, it says that we understand that assessment can take place under the new provision, but since the old notices has been said that it is bad in law, and Supreme Court has struck down all the notices. Therefore, the position has come that no reassessment can take place, and therefore the revenue is in vacuum here. The revenue cannot be made remedialess. Here the law turns here. Here it goes toward the public interest. From this line, it goes to the public interest, and the object and purpose of the reassessment cannot be frustrated. This is the first line which the Supreme Court is taking the deviation from the High Court. It is true that due to bona fide mistake and the view of the subsequent extension of time by various notification, the revenue issued the impugned notices under 148 after the amendment was enforced with effect from 1st April 2021. Under the unamended. In our view, the same ought not to be issued under the unamended Act and ought to have been issued under the substituted provision of Section 147 of 151 of the IT Act as per the Finance Act 2021. It is the further affirmation of the High Court judgment here. There appears to be genuine non-application of amendment as the officer of revenue may have been under the bona fide belief that the amendment may not yet have been enforced. Now it goes that how the revenue has enacted. Revenue has enacted on a bona fide belief that the notification is still valid and the date of 30th June 2021 can be the timeline up to which they can issue the notices. Therefore, we are the opinion that some leeway can be shown in that regard, which the High Court could have done so. Very much important point. Though. Now it is carving another point. He is finding out leeway and also pointing out these leeways could also be given by the High Court under Article 226. Now the point comes here, the point comes here, whether the High Court was empowered under Article 226 to give such type of leeway, which the Supreme Court is giving under the Article 142. My understanding that Article 226 is a much wide power, has a much wide power, and the court, if the court had thought this type of things, they would have applied the Article 226 to give such type of leeway. Therefore, instead of passing and setting aside the reassessment notice issued under the unamended provision of the IT Act, the High Court ought to have passed an order construing the notice issued under the Unamendment Act or unamended provision of the IT Act as those deemed to have been issued under 148 of the IT Act as per the new provision of the 148, and the revenue ought to be permitted to proceed further with a reassessment proceeding as per the provision of 147 of the IT Act of the IT Act as per the Finance Act 20, subject to compliance of all the procedural requirements and defenses. We will come to the defenses subsequently, which may be available to the SSC under the substituted provision of 147 to 151 and in law. Therefore, we propose to modify. So, the Supreme Court has given a leeway, which the status which was there, that a status was there after the High Court, the no reassessment proceeding can be started. Supreme Court has said that in the interest of the larger interest of the revenue, there cannot be any vacuum here, and therefore he has tried to carve out a leeway which gives an opportunity to revenue to do the reassessment, and for this purpose, and since the procedure law are the same, so in this purpose he goes back and says that these notices will be considered as notices under 148A subclause B. Very much important point is that with this, Supreme Court has done some balancing act. How the balancing act has been done? First balancing act that when the Supreme Court says that these notices will be deemed to be a notice under 148A(b), in the same time, it says that the other defenses which is available to the SSC, what are the defenses available to the SSC is quite defenses of the 148, defenses of the 149, defenses of the 147, what are the defenses which is available to the SSE, it is still there. So no defenses has been curtailed. All the defenses are still there with the revenue, with the SSE. So it is a balancing act while empowering the revenue to go for the reassessment, in the same time giving the SSE an option to defend it as per the law also. And therefore, one more point here, if we come to the para 8.1 and how to read this law here, I'm going to the para 8 substantial judgment here, order. It says that the respective impugned section 148 notice issued to the respective SSE shall be deemed to have been issued under 148 of the IT Act as substituted by the Finance Act 2021 and treated to be so-called notice in terms of the 148AB. So therefore, it does not say the notice will be under 148AD. It says that these notices will be under 148AB. There is a procedure. When the assessing officer has some region or some information, they can start the inquiry subject to the approval from the specified authority. After that region, they can issue the notices to the SSE, and after this notices, the SSE can reply this and can file its objection under 148AC. And after this, considering this objection, the assessing officer can file and can pass an order with the approval of the specified authority under 151, and this order will be given along with the notice under 148. However, the Supreme Court says these notices under 148 will be treated as a notice under 148AB, not under 148AD. So it is a so-called notice under 148AB. The respective assessing officer shall within 30 days from today provide to the SSE the information and material relied upon by the revenue so that SSE can reply within 2 weeks from thereafter. It gives another task to the revenue officer, say that you will provide the reason to believe. Earlier, the reason to believe we used to get it after filing the return. Now, what will happen? The assessing officer has to provide the reason to believe why this reassessment proceeding has started. And after that, and that has to be given within 1 month. And after that, the SSE can file their reply within 15 days, that is 2 weeks here. So this is the one of the important point. Second point is very much important. The requirement of conducting inquiry under 148A has been dispensed of. This is the one-time waiver that has been given to the vis-a-vis notice which has been issued under section 148(2) of the amending act from 1/4/21 till date, including those which have been quashed by the High Court. Very much important point is that a lot of my colleague has raised the issue. So what is the meaning of the till date? Whether the notice which has been issued after 1st of July 2021 under 148 will also be covered? My understanding is that no, that will not be covered. The benefit of this judgment will not to that judgment, to notices, because the dispute was there, qua the notices and qua the notices which has been issued post 1st April 2021 till 30th June 2021. So therefore, the benefit of this judgment will be available to those notices only, with the notices which has been issued post 1st July 2021. They cannot avail the benefit of these notices. That notices has to be challenged on the different ground here. So first point about which I'm trying to say, the notices which has been issued post 1st of July 2021 cannot be considered to be a 148AB notice in the light of this judgment here. All the defenses, the assessing officer shall thereafter this ones, and the second para is there. The assessing officer shall thereafter pass an order in terms of the section 148AD following the due procedure as required under the 148B in respect of each of the concerned SSE. All the defenses which may be available to the SSE under 149, which may be available under the Finance Act, and in law, whatever rights are available to the SSE, assessing officer under the Finance Act 2021 are kept open and shall continue to available. And This is the very much important one. This is the balancing here, which says that SSC will have the right to defend these notices. And fourth point is that the purgent order shall substitute, modify respective judgment order passed by the respective High Court quashing similar notices issued under unamended 148 of the IT Act, irrespective of whether they have been assailed before this court. Here the Article 142 comes into when the revenue said for the larger interest of the revenue, the reassessment cannot be in vacuum, and the Supreme Court has found a leeway. So therefore, by this leeway, it has given a lifeline to a stillborn notices, to a dead notices. And when such lifeline has been given, it has given not only those notices which are before the Supreme Court, it was also given to the notices, all the notices, 90,000 notices, which may have been assailed before the Supreme Court, or which have been penned, or which have been against which the High Court has passed an order, or which has also not been challenged before the Supreme Court. All the notices in the timeline of 1st April 2021 to 30th June 2021, in pursuance of the notification, has got a lifeline now, and this lifeline will be in terms of 148A2B notices.
Prakash, sorry for interrupting.
Yeah.
If you can conclude in the next 2-3 minutes, because it is 6:40.
Yeah.
I think Honorable Srivastava may have joined. I don't know. I can't see the screen because there is a PPT here, so I don't know. But once you finish, then we'll.
No, so he has already. Sudhanshu sir has already joined, and he's and he is already there, sir. Okay.
Okay. Yeah.
One more important point which I would like to say that here. We have seen that Article 142. Sanjeev sir has read the Article 142. 142 has been, it was said that 142 has earlier been invoked in few of the judgment, particularly of the judgment of the two tax judgment, and one I can recall that synthetic chemical judgment, and another was the photographic industry judgment here. I don't have the complete citation of this judgment as of now, but I can understand in these two judgments here, particularly in the synthetic chemical judgment, one was from the state of UP, and there was the issue of the taxes where the Supreme Court has said that these taxes will not be applied. These taxes will be applied with prospective post judgment here. So there was also issue of the prospective overruling in terms of the Golaknath cases here. Another point which I would like to say that the TOLA was never challenged before any High Court. Only challenge was notification number 20/2021 and the 38/2021, which empowered the assessing officer to issue the notice 1st April 2021. So therefore, there is no comment on the TOLA either by the High Court or the Supreme Court. Therefore, we can conclude that TOLA is not unconstitutional. TOLA is a constitutional law because both of the TOLA as well as the income tax has been passed by the Parliament. Has been passed by the Parliament here. I have also discussed about the procedural law issue, the effect of the procedural law. One point that is coming to our friends here: what will happen to the assessment year 13-14 and 14-15? In my understanding, 13-14 and 14-15 is protected by the old provision of the 149, which says that there cannot be assessment notice of the reassessment for which it was time barred under the old provision itself. One more important point is that the notices which will be called now is a notice under 148A2B. So therefore, the new provision is going to apply. When this new provision is going to apply, then we have to see the limitation of 3 years as well as the 10 years. The point arises here, if it is 3 years, if it is the income which is kept is lesser than 50 lakhs, and if it is rare cases, if it is more than 50 lakhs, then the revenue can go up to 10 lakhs, subject to compliance of certain law where under 149, there's a certain different provision has been worded, because under the 147, the provision is that if there is any information which suggests there is an income escapement of the income. However, under 149, when there is a provision over 10 years has been there, the wording is quite different. We have to see that how this wording will be applied by the revenue, and we can defend our cases from that point of view also. So these are the few observations that I have tried to make here.
In fact, I will not be sharing my personal views, as I was telling Prakashji also. I would just like to add few things. This hullabaloo about invoking Article 142, and you were also mentioning few cases. Apart from that, there is a case of A.R. Antule versus R.S. Naik also, wherein this article was invoked, and it was stated that Supreme Court can grant appropriate relief where there has been some manifest illegality, where there is a manifest want of jurisdiction, where some palpable injustice is shown to have been resulted. Then there was another case of Manish Goyal versus Rohini Goyal, where the apex court ruled that the court can grant equitable relief to eradicate injustice. There's another case of Anil Kumar Jain versus Maya Jain, Union Carbide Corporation versus and others versus Union of India. So there have been umpteen instances where this resort to Article 142 has been done. Although in recent times, of course, I think this A.R. Antule judgment is 1988. Then Manish Goyal is 2010. Anil Kumar Jain is 2009. And Union Carbide is 1991. So most of us, at least I don't remember coming across these judgments when I was practicing as an advocate. But yes, this is definitely a watershed in the, you can say, in the tax jurisprudence. And the Honorable Apex Court has tried to balance the interests of the revenue as well as of the SSEs. Although I have my doubts regarding can we put the clock back on something which has happened. Maybe it was due to misunderstanding of a particular provision, or maybe the department was not geared up to really come to terms with the new amendment and go forward. But well, then it's the Apex Court's judgment, and we all are bound by it. More privately, maybe we can have some more heated discussion on the topic, but yes, it did come as a surprise, because most of the tax practitioners, they were very, very hopeful that this kind of judgment would not be forthcoming. And there are a few takeaways from this judgment. One is where the revenue has acted bona fide under the impression that through the notification, such notice will become valid, and subsequently High Court quashing all the notices, saying that such notices are not permissible under the amended provision, but it can be permissible under the amended provision from 147 to 151. Supreme Court has taken a view that, well, the revenue cannot be left remediless. And another thing which is very noticeable is that how the Honorable Apex Court, it has blended the constitutional power with the judicial discretion. It has applied that doctrine of complete justice as envisaged in Article 142. If you go through para 9 of the judgment, here the Honorable Apex Court has tried to draw that this judgment is the outcome of a broad consciousness, so that neither revenue should suffer from its right to reassess, nor should the defenses which are available to the SSC, they should be curtailed. So these are my quick impressions, and I congratulate Prakash ji also for being so thorough in his studying this judgment and bringing out the finer points. It is always a pleasure to read a judgment with Prakash ji. So thank you for all the efforts.
Thank you, sir. Thank you, sir.
Thank you very much, sir. Thank you very much. I think we still have a couple of minutes before I, shift to Mridhu. I'll just make one point, Prakash, if you want to respond, or sir,
Yes,
if you
sir.
want to make any comment. Someone posed a question to me. Is it possible to file a review tomorrow? And I mean, it's a question which is worth looking at. And one senior advocate said, look, almost 99.99% cases, the review is dismissed, has been dismissed for whatever be the reason. I mean, they have not been discussed in the open court, except one judgment where the court is open to listening to the parties, the case of the software, maybe in the review petition in the open court. But generally, a review or a curative is more a correction of an error and instead of a review of the judgment. And here the judgment is so very clear. So don't be so hopeful about review or a curative. Any thoughts, sir, you may have, Prakashji, you may have for the benefit of everyone?
With the permission of sir, may I state something, sir? Srivastava, sir, may I state something?
Yes, sir. Yes, sir. Please.
Okay. Here I would like to two things, sir. First of all, before going on the review part, on the Article 142, there is a famous case that is the Vatika versus State of Rajasthan in the POXO case here, which was the prevention of the sexual harassment case here. It was the Supreme Court made law, which was further, after Supreme Court made the law, then it was amended or passed by the Parliament, and the law came through the Parliament. So the POXO Act is the outcome of the Supreme Court judgment under Article 142, Vatika versus State of Rajasthan, very famous case that we can understand there. The second point, which is on the point of review, I will tell, sir, there are two important judgments of the recent Supreme Court, which the revenue has filed a review. First was the canon case under the custom, where the terminology of the proper officer was discussed, and on that canon case here, lot of judgment was there because the Supreme Court had struck down certain provision of the Customs Act and notification of the custom under the custom. That judgment has been challenged by the revenue or under the review petition here. The second, sir, has mentioned that about the software judgment here, that that has been filed under the review here. Look, review can be, the scope of the review is very narrow. The scope is very, very, very narrow, and it is all depends upon the discretionary power here. Here I find that the Supreme Court has done a very balancing act. It is not said that only it is a favor of the revenue. It has also given something in favor of the SSC. My first impression when I have heard about this judgment through WhatsApp here, I thought that it is a revenue favoring judgment, but I am mistaken here. It is not a revenue favoring judgment. It is a balancing judgment, which says that the revenue will be, these notices will be construed as notice under 148A(b). And after that, all the defenses which are available to the SSC is open. So therefore, all that, and it is also one more point here, it has also clarified here, since what he has clarified, these notices will be the notice under the new act. So therefore, the doubt which was there for the 1314 and 1415 under the old assessment, in my personal understanding, that there should be no any doubt here. This is the positive point that I will try to read from the SSC perspective here. So
fine, Prakash. I think you are trying to strike a balance yourself. But yes, sir, please. Sorry, sir, please.
What about this gray area of assessment year 13-14?
Sir, I have two issues on this submission here. As per the amended 149, which says that if the limitation period has expired under the old provision itself here, then therefore, no reassessment proceeding can be initiated under the new amendment here, which is the provision of the 149. 1314 was the 6-year period. It expired on 31st March 2020. By the Relaxation Act, it extended up to 31st March 2021. So that notices, and if that notice has been issued post April 4, 2021, that notice is no more valid here. First point is that. So 1314 and 1415, my understanding that no notice can be valid here. Yes, I feel that also 1516 and 1617 also. 15, 16, 17, because now the new law will come and the 3 years and 10 year will apply. The moment it will say the 3 year and 10 year will apply, then what will happen? 2021, 1920 and 1890. These are the 3 years where we can apply it. After that, unless there is a criteria of 50 lakhs rupees, more than 50 lakhs, and the condition being fulfilled under the 149, that only can apply. So my understanding that I can read more positive as a SSC perspective rather than negativity here from the SSC perspective here. So I'm very much this one's here that Supreme Court has clarified much more things here, but still there are a lot of things to be clarified also. I can understand.
Yeah, so the litigation is going to increase. See, once these notices are issued, the orders are passed. I'm sure, like some people were saying, the litigation will finish. I think the lawyers like Mr. Prakash and others will have a lot of money and a lot of time to spend on the notices and the orders which will get passed in those 90,000 cases and many more. I don't know. But I think very quickly, Prakash, one or two small questions which are there in the chat, and then we go further. One question is from Nitin Furia. Since the counsel from both sides agreed to the judgment, can review is possible? I think Nitin, the review is possible if there is an error in the judgment. As Prakash said, the review powers are very narrow. You're not reviewing the principle of the judgment. You're just reviewing if the error has crept in. So I think that's possible provided there is an error in the judgment. And yes, Prakash Gaurav had raised one or two questions. I'll just read them out. One is, what is the use of defense if what the assessee was asking for has been denied upfront? So assessee was asking for the notice to be quashed. Then what is the use of this defense? I think a very strong question, but that's a question which I think a lot of people may have. And the second question, which you have already answered, has TOLA been impliedly overruled? That you've already answered. And one question which Saurav has again put is, but for 1314, Revenue's case was that the reassessment notice is valid under TOLA notification, right? So these are the 2-3 questions from Saurav. Please go ahead, Prakash, and then we will go to the next speaker. It is already 7 o'clock, but take a couple of minutes to respond to this.
My point is that, sir, we have to read this judgment from the holistic point of view, from the overall point of view. It is not a one case, sir. It is a case of the 90,000 notices, which the revenue has said that the notices has been issued under an bona fide impression that notices are valid and the procedure law are the same and there's no difference in the procedure law. So therefore, if we understand this judgment from not only from one SSC point of view, but from the in a larger perspective point of view, then we will find that these notices are, these judgment are quite a good judgment, quite a balancing judgment, not hurting the revenue and not also taking away the right of the reassessment where there is a permissible under the new provisions here. This is the first point which I like to say. What was the last question, sir? I just missed it, sir.
So the last question was, but for assessment year 1314, revenue case was that reassessment notice is valid under TOLA notification, right?
So I will like to state, sir, Supreme Court has not turned around the case of the High Court. High Court order is still valid. High Court judgment is valid. Supreme Court has not said that the High Court order was bad in law. Supreme Court has simply said the notices which has been issued post-April 2021 will be considered as a notice under the 148AB. Therefore, for the 1314 and 1415, we have the protection of the section 149 proviso clause. Therefore, when the 149 proviso clause is there, which says that under the new provision, the no notice can be issued if the assessment was time barred under the old provision per se. So therefore, my understanding that we are protected by this judgment here, which says that because 148A2B is qua the new act, not the old act. So the moment it is in qua the new act, the ratio of 3 years and 10 years will apply, not the 4 year and 6 year will apply. So therefore, the limitation which has been barred under the old provision, that is not going to be reopened under the new enactment of 148A.
Fine, Prakash. I think I'll be very honest and blunt, Prakash, as I'm known to be. It appeared to me a couple of times that you're probably arguing the case of the department much more than giving us the view on the Supreme Court judgment, because you see, the SSCs had gone that the notices have been quashed by the High Court. The notices have been now modified to that extent that they have been not been quashed. So to that extent, it is a judgment favoring the revenue to say, well, you may have misread the law under error, create the notices you can't be left without any remedy. But there are equally judgments. If these were not 90,000 cases and were only 90 cases, would the judgment have been different? So there are a lot of things which will come up, which can be debated. An SSC whose case has been reopened will obviously be impacted to say, well, I've been impacted. I don't care about the other 89,000 cases. I had a judgment of the court saying, well, the notices have been quashed. So somewhere I think if you're impacted personally, you may have a different view. As legally, and as Sir said, we can debate. And I remember, Sir, I remember, Justice Sikri was in the High Court, and the counsel was arguing a case, and he said, look, Your Lordship, the judgment of the High Court can be interpreted like the Supreme Court. And Justice Sikri said, look, you interpret the judgment, we'll follow the Supreme Court order, because we will follow the law laid down by the Supreme Court. So it's a law laid down by the court. We can keep on, having our views, our thoughts, our reactions, nothing more than that. And with all respect, all of us, I think, bow down to the Supreme Court order to say, well, it is a final order, it is a law of the land. And let's hope there's less litigation. But the worry is that there may be more litigation, because once the notices are issued, there will be questions on information, what is supposed to, are they valid, are they correct, not correct, etc., etc. Orders will be passed, 30 days time, 15 days time not given, natural justice not followed, etc., etc. So we can get into a debate probably more and have one more session on this after some time.
So before getting into, and as Sanjeev sir has introduced the topic, that, the issue regarding that was involved in this particular judgment was specifically on the taxability of vessel hire, and whether that vessel hire could be assessed under the provisions of Section 44BB, and whether it was applicable in this situation. Now, before getting into the judgment, I would just briefly familiarize the audience with the provisions of Section 44BB. This particular section was introduced by Finance Act 1987 and effective from April 1983. Now, this section is a special presumptive scheme for non-residents, and specifically non-residents which are engaged. So there are two legs to the section: non-residents who are engaged in the business of plant and machinery on hire, which would be used in the business of prospecting, extraction, production of mineral oils. So this is a very specific section that has been brought in, and in case a non-resident is falling under this provision, it would be deemed that the income of the non-resident would be deemed to be only 10% of the gross revenue that would be received from these services. And effectively, the tax rate would come out to be anywhere between 4.24% to 4.36%, because by deeming the income to be taxable, deeming the income to be 10%, an applicable rate of 40%, the effective tax rate would be around 4% on the gross revenues that would be earned from those particular services. Now, given this background, the applicability of Section 44BB has been a matter of litigation. This is a beneficial provision for the non-residents, and usually the non-residents engaged in such business would take a position that, either they are not taxable in India, or in case they are taxable in India, they fall under the purview of 44BB. Whereas the tax authorities allege that, the income that is received from provision of these services or the hire of plant and machinery would be either assessed as fee for technical services or royalty under the Act, and therefore provisions of Section 44BB do not apply to such situation, which is why there have been a number of cases which have been brought up before the courts for discussing the matter. In this particular case as well, this was the matter which was in the court for the whether the higher charges that were paid would come under the purview of Section 44BB. Briefly discussing the facts of the case. Now, L&T Larsen and Toubro was awarded a contract by ONGC, and this contract was for the purpose of design, survey, procurement, fabrication, and an elaborate contract for an end-to-end services for commissioning of a BCP booster compression platform. And this was at an offshore location in Bombay High. Now, this platform was going to be used for maintaining and enhancing the production and capacity of mineral oils. For the purpose of executing this particular contract, L&T had to hire tugs and barges from various non-resident entities. And just a brief background on that. What are tugs and barges? Because these are very typical issues to the oil and gas industries and the shipping industry. And I'll just give a very, very brief understanding of what these are. Tugs are basically, they are marine vessels which are self-propelled, and they maneuver other vessels, either they push them or pull them. And barges are cargo ships which carry cargo, etc. for transportation. Barges are usually not self-propelled, so they need tugs for their movement. So usually in such a situation, tugs and barges are usually, they come together and they're hired together, which was the case in L&T as well, where L&T went into an agreement with 6 non-resident parties, and there were tugs and barges which were hired for this purpose. There was another aspect which is peculiar to this industry, is that the tugs were hired on a time charter basis and the barges were hired on a bareboat charter basis. Now, again, very briefly going into what bareboat charter and time charter means is, so basically bareboat charter is where, just the ship is given or the vessel is given for hire. There is no crew that comes along with the vessel, and the vessel is 100% in the control and supervision of the hirer. Whereas in a time charter arrangement, the ship or the vessel along with the crew members are also given to the hirer, and the entire the employees or the crew that is available on the vessel are under the control and supervision usually of the owner of the vessel, whereas however they work on the directions of the hirer. So these are two types of arrangements which are there. Now, there are some issues around taxability of bareboat charter and time charter as well. However, this particular issue was not taken up in this judgment, and therefore we're not getting into this. What, however, happened in this judgment, and the facts that I'm going to be discussing was that the tugs were hired on a time charter basis, and the barges were hired on a bareboat charter basis. Now, L&T, given the fact that these equipments or these vessels were going to be used for the purpose of implementing the contract with ONGC, L&T was of the opinion that the payment that it was going to be making to these non-resident parties would be governed by the provisions of Section 44BB and therefore should be taxable at an effective tax rate of 4%, which is why it filed an application with the tax officer for obtaining a withholding tax order for a 4% withholding on these particular payments under Section 44BB. Now, initially, the assessing officer accepted the contention of the taxpayer L&T and was of the view that the arrangements did fall within the purview of Section 44BB and therefore provided a certificate which was applicable effective till 31st of March 2008 with a 4% order. However, right after providing the certificate within a month's time, the AO again questioned L&T as to why Section 44BB was applicable in this particular situation and why not this arrangement be taxed as royalty under the provisions of the Act, particularly Clause 4A of Explanation 2, which talks about equipment, the right to use of equipment for commercial purposes or scientific instruments for the purpose of use and categorizes that royalty. The taxpayer did provide its contentions against the questions raised. However, the AO was not convinced and passed an order that the taxability should be at 10% and considered the payment as royalty and directed L&T to withhold taxes at 10% plus the surcharge and the cess. The AO thereafter, L&T filed a review petition again under Section 264, where again it was upheld that the provisions of Section 44BB do not apply in this particular situation and the payments ought to be taxed as royalty. Which is where this writ petition came into being and agreed by both the lower authorities' judgments and orders. L&T invoked the writ jurisdiction of Bombay High Court. So in this particular case now, L&T's position and contentions were that the revenue was misdirected in holding that the payments were royalty in nature. The issue was that the provisions of royalty as per the Act specifically provides an exemption, a carve out for amounts which are referred to in 44BB. However, the tax authorities at both the levels did not consider that carve out at all and held that the payments would be considered as royalty. Also, there was another fact that the petitioner contested was that the revenue had adopted a very narrow view while discussing the provision of Section 44BB and in saying that the fact that the phrase that is mentioned there in connection with that it does not apply in this particular case and had a very narrow interpretation of the matter. On the other hand, the revenue's contention was that they were still on the fact that the Tugs were barely transport equipment and therefore they were under the provision, they would come under the provisions of royalty. The revenue categorically
There is some disturbance from Madam's side, sir.
Yeah. Has she been disconnected?
Is Madam online?
Yeah, she's there. Mridhu, we can't hear you. Actually, we can't even see you now.
Yes,
my
sir.
apologies, I got disconnected. I'm sorry. I'm just sharing the screen again.
Please. Yeah, we could not hear probably the last 30 seconds.
Sure. I think I will switch off my video if that helps. My internet connection seems to be a little unstable at the moment.
Yeah, please. Not a problem.
So I would, so the revenues contentions, I would discuss the revenues contentions again. I believe I got disconnected there. The revenue was very clear on their interpretation that the payment for tugs and barges would continue to be under the purview of the provisions of Section 9 as royalty. They had categorically mentioned that Section 44BB only applies specifically to the parties which are engaged in the actual exploration, extraction or production of mineral oil, and not to anybody else, or not to who's indirectly involved in the business. They did mention that the petitioner, although this is a observation that the AO made while passing the initial order, that the petitioner was not in the business of exploration of mineral oils and merely assisting ONGC, which is why the provisions of 44BB should not be applicable in this particular instance. And another aspect that they brought out was that tugs and barges were mere transport facilities, and Section 44BB should therefore not apply in this particular situation. If you would see, if my slide is available, the explanation to clause 6A, 4A, specifically mentions that the use or the right to use of any industrial, commercial, or scientific equipment, but not including amounts referred to in Section 44BB, would be considered as royalty. So just the limited issues here were whether the tugs and barges qualified as royalty, whether 44BB would be applicable to the payments made to these non-residents, and whether in effect 44BB is applicable only to non-residents which are actually engaged in exploration, extraction, or production of mineral oils, or does it get extended? So the Bombay High Court has very categorically taken up each aspect here, and it did lay down that, you know, for the purpose of Section 44BB, there are certain basic criteria which should be met, and those criteria being, for example, that the residential status has to be a non-resident. The business, such non-residents should be engaged in the business of providing facilities or supplying plant and machinery on hire. The nexus has to be with the prospecting for or extraction or production of mineral oil. The plant and machinery supplied should be again used in prospecting extraction of mineral oil. And where all these criteria are fulfilled, the applicability would be that the income of such a non-resident would be deemed to be 10% of the aggregate amounts. Now, the High Court also particularly held a few things in this particular judgment. One, that the revenue was had excluded from its purview or from its discussion the applicability of 44BB to royalty specifically, that there is a carve out in the section which has not been discussed. And they very specifically mentioned that the language of the provision Section 44BB does not anywhere state that only the people who are, or only the assessees who are directly involved in the service, using the services or the plant and machinery for the purpose of exploration, extraction, are only eligible for this particular presumptive scheme. So what was said was that what is needed to be seen is that the connection for which the end use or the purpose for which the services, facilities, or the plant and machinery were being used. And the linchpin of this particular provision is that where they are inextricably connected to the particular activity of exploration, extraction, or production, as long as there is an inextricable connection, the provision of Section 44BB should apply. Now, there was an aspect which was brought out that the tugs and barges were mere transportation and they were mere equipment which were used for transportation. So here the court has categorically again mentioned that Section 44BB does provide for and does include in its explanation or clarification that plants includes ships, aircrafts, and vehicles. So, it brings into its purview the transport, the equipments which are used for transportation, and that can be used for the purpose of exploration and extraction and production. So it is not just limited to facilities or services. The High Court has relied on the Honorable Supreme Court's judgment, which is a landmark judgment in the case of ONGC versus CIT. And the Supreme Court had laid down various aspects as to how the applicability of Section 44BB should come into play. And one of the most important aspects that were brought out in this judgment was that the pith and the substance of each agreement needs to be seen to see whether 44BB should apply, and where again, where the agreement is such that it is indispensable or it is inextricably linked or connected to the activities of exploration, extraction, and production, the provision of Section 44BB should be made available and should not be restricted only to the assessees who are actually engaged in the process of extraction or production of mineral oil. Now, the key principles that came out of this judgment were that the expression "in connection with" should not be read in a narrow sense. In fact, it expands the horizon of the services, facilities, and the plant and machinery that fall within the ambit of this section. They have placed reliance on Supreme Court's judgment in the case of ONGC versus CIT, that the pith and the substance of each agreement is very crucial to ascertain whether the proximity that the work or that facility or that plant has to the process of prospecting, extraction, and production of mineral oil. Also, another important aspect that has been brought out with this particular judgment is that applicability of Section 44BB is not just restricted to the persons who are directly involved or enter into the contract with the person engaged in actual activity of extraction. So it has a wider meaning, it has a wider coverage. This judgment has now been in line with a lot of judgments that have been there, and it doesn't diverge particularly from this particular aspect that that 44BB needs to be read in a more comprehensive manner, and the idea is to provide that in connection with, or the purpose is not to read it in a narrow sense, and the idea is to provide the benefit to assessees. I would very quickly discuss a couple of judgments which were there especially prior to the Supreme Court's judgment as well, which have laid down very similar aspects as the Supreme Court's judgment and also the judgment of the Honorable Bombay High Court in this particular matter. So this particular case of Valentine Maritime is I'm discussing here because this is again very similar, because it also talks about tugs and barges, and in this situation also it was very clearly held that because the tugs and barges were ultimately used for the purpose of were used in the business of prospecting, so it had to be read in a wider manner and could not be just restricted to the fact that the person, the owner of these tugs and barges were not actually in the extraction of mineral oils. So this particular judgment again in line for tugs, specifically for tugs and barges being specific vessels. This particular judgment also relied on the judgment of SBS Marine, which is a very landmark judgment in this particular matter of 44BB. This is one of the initial judgments which has clarified a lot of issues pertaining to various contentious matters that were there in the applicability of Section 44BB. And the Delhi Tribunal has very clearly laid down a lot of things. And one of the aspects I would just highlight, one of the aspects that was highlighted in this particular judgment, which has connection to our particular cases, that while the judgment does discuss about the fact that again the section has to be read in a wider manner, and any connection or any proximity to the business of extraction should allow the applicability of Section 44BB. And this case, I would just like to highlight that this particular judgment was passed before the Honorable Supreme Court's judgment in the case of ONGC, but held very similar, was on the very similar lines as the case of Supreme Court. They have particularly mentioned that there can be no dispute that an aircraft or a vehicle cannot be directly used in prospecting of for extraction or production of mineral oil. The Section 44B does not envisage direct use of plant and machinery in prospecting or extraction or production of mineral oil. So very particularly hitting this particular matter, where as highlighted by the Honorable High Court also, that the definition of 44BB for plant in itself provides for ships, vehicles, and aircrafts. So the intention of the particular section has always been to give it a wider purview, to include anything and everything that has proximity or nexus to the actual business of production or extraction of mineral oils. So there's another case law which is very similar, and I'm not in the interest of time, I will not discuss that. There are two more case laws. I would just highlight the case law of Floyd helicopters, which was again a judgment which was passed in 2001 and was much before the ONGC judgment. And there also, to the extent that helicopters were provided for the ultimate transportation of goods and manpower, the AAR held on the similar lines that, you know, the idea is whether the ultimate usage of the plant and machinery or the facility or the service, what kind of nexus it has to the business of prospecting and extraction of mineral oils. And as long as there is a proximity and a connection that can be drawn, provisions of Section 44BB should be made applicable. I'm just going to be discussing very briefly this particular case of Pumpoha shipping, although this case is a little divergent in the view that the Madras High Court in this matter held that bareboat charter and time charter both qualified as royalty under the Act and did not give the benefit of, and for that matter, Section 44BB was not discussed at all in this particular case. The contention was whether vehicles or vessels qualified as equipment, and Madras High Court in this particular matter held that, you know, vessels, ships did qualify as equipment and therefore came within the purview of royalty because it qualifies as equipment. Now, an interesting aspect is that Madras High Court later on in its own, in the case of Van Ord, has themselves held that bareboat charter should not qualify as royalty. So they have, in their own matter, they have given a judgment that while the aspect of time charter still remains, and there's an SLP which is pending in this particular matter, but they in their own case have held that bareboat charter does not qualify as royalty. Now coming to the main judgment, which is the Supreme Court's judgment in the case of ONGC, being the landmark judgment, just highlighting, which we have already discussed, and a lot of case laws are on the similar lines, but I'll just highlight the key principles that emerge out of this particular judgment. Now, the term mining or like projects was not defined and not discussed in any of the case laws. The Supreme Court took upon itself and it evaluated the term and did lay down that production of petroleum did amount to a mining activity, and therefore, for the purpose of the definition of FTS and for the purpose of 44BB, mining and like activities would include extraction of petroleum and products. The principal matter that came out was that what is important is to be seen the pith and the substance of the agreement and the fact whether it is inextricably connected to the activity of extraction or production of mineral oils. If that is the case, then all such cases should be covered under 44 BP, even if they include certain ancillary services. And the third aspect that because this judgment was basically on the issue before the Supreme Court was whether in a particular matter provisions of Section 44 BB applied or Section 44D had to apply. So given the nature of the contracts and given the nature of the work that was being undertaken, the Supreme Court was of the view that the definition of that given that there is a specific exclusion in the definition of royalty and FTS, where the dominant purpose of the agreement was again for the purpose of extraction, production of mineral oils, Section 44 BB should apply and not Section 44D.
There's a very old order of ITAT Delhi bench in which they had held that even giving these vehicles on hire, they will be eligible under 44 BB.
Yes, sir.
Yeah. Schlumberger Corporation, 2010 order.
Yeah.
So maybe that is the time from when the jurisprudence started in favor of 44 BB.
Yes.
And recently also there was another Delhi High Court judgment, Paradigm Geophysical. So that again has, they are almost on identical lines.
So I think, go ahead, Prakash, go ahead.
Subsequently, OHM case has also traveled to Supreme Court, sir. But there are a lot of issues that we will discuss at the end of the session, sir.
But ONGC has settled most of the things, but has this issue of PE been discussed in the Bombay High Court? Whether a PE should be there or it should not be there?
No, sir, the issue never came before. That was never the contention or the issue whether these 6 taxpayers had a PE in India or not. The only contention was whether it was royalty or whether 44 BB should apply.
Sir, the 44 BB can apply only when there is a PE, sir.
No, but somehow in most of the judgments, it is conspicuously missing.
Yes.
Discussion about PE is missing. Very right, sir. Very rightly observed.
And coming straight to the ruling, it is one of the very interesting rulings, especially in the context of digital economy, which we talk about on a daily basis. In our international tax, practice, or in the cross-border taxation practice, there are various remittances which go in and out of India with respect to the database services, with respect to the services which are given to any software company for using some of the for using some of their software portal. It's a technologically driven environment, and for this is one of the important and interesting case laws which will help us in the day-to-day practice as well. Salesforce Pte Limited, Singapore-based company. Let me share my screen and then we'll deliberate on the case law. Is it visible to all?
Yeah,
Yes.
So, like, it's a case law on the treatment of the subscription fees, which is received by the Salesforce Singapore from the Indian customers or from the Indian entities. So the entire, the fact is illustrated in this diagram, wherein the flow of the payment or the consideration is from India to Singapore. For what? For using their CRM software portal so that the Indian customer can actually enable itself to systematically generate the report by putting the data or by feeding in the data which belongs to the Indian customer only. It is not the data of any third party, or it is not the data which is collated or gathered by the Salesforce. It is primarily the Indian customer's data. It inputs the data, gets access to the CRM software portal, which is owned by the Salesforce, and gets the business data reports or the information reports, or the analytic reports on the marketing campaigns which the Indian entity runs, tracking leads, and so on and so forth. And the consideration is accordingly paid. So let's understand the flow, what the CRM portal actually is. It is a comprehensive customer relationship management portal, which is owned, developed, and created by the Singapore entity in our case. So in which, simply put, there is a lot of technology involved in the backend, no doubt about it. And that's what the major contention of the department and the revenue was as well. And it was a very right contention of everyone for that matter, because CRM is a result of a programming, coding, languages. A lot of professionals who have specialized knowledge in this space can create this kind of a software portal, which can actually help the Indian customers or the Indian entities to get the reports in the manner as they desire it to be. So a simple diagram on the CRM application software portal: data is input by the customer, and then it gets feed into the system backend of the CRM, and then the data is retrieved in the desired format, which is asked by the Indian customer. Issue main, like coming back on the issue once again, it was the subscription fees received from the Indian customers, whether it should be taxable under section 115A of the Domestic Tax Law of India, Income Tax Act, at the rate of 10% in royalty, by making it chargeable under section 91 VI, or under article 12 of the India Singapore Treaty at the rate of flat 10%. Arguments by the revenue were valid on their on the infrastructure of the CRM. I would say that was my understanding after reading this case law, because revenue contended that whatever the Indian customer is actually getting is a result of a web service, is a result of a highly technical driven solution which is created and developed by the sales force. It is not a simple infrastructure being put by the sales force. It is highly technical, and the Indian customer is getting the right to use that equipment, or to getting the right to use that intellectual properties or the know-how or the system which is created by the sales force, though the ownership was nowhere disputed in the said case law. Further contentions was all of the contentions revolve around the technologically enabled solutions. So according to them, it's a process. It's a process wherein the first step is the cloud computing service or the CRM software portal is set up. And the second process is the client, Indian customer, is able to enjoy the process, able to use the process and get the data in the desired format. This is so complex level, high technology involved in this, and the customer is the ultimate beneficiary. Indian customer is the ultimate beneficiary. He is able to get the report generating out of such a complex, highly driven technology, based CRM portal. Before arriving at the characterization of whether this payment should fall under 91 VI or not, one of the main go-to documents is the master subscription agreement, wherein the different clauses states what means what, customer data means what are the rights involved of the both the parties, what are the rights when it comes to the protection, what are the usage restrictions, what is the number of days that the sales force has to provide the data with, or what is the maximum number of days the sales force has to keep the data with itself, or to get away with the data, how the rights are going to be preserved, what is the nature of the license that is granted, what is the nature of the subscription that is granted to the Indian customers or the employees of the Indian customers, what is the information, and what are the rights of the ownership on that information, who is going to own the intellectual property in the entire. So these are all the extracts from the master service agreements of the master which has been entered into with the sales force and the Indian customer. Summing up the entire master subscription agreement, it could be inferred that it was not a use of intellectual property which is owned and created by the sales force. First of all, it was just an access which was granted to the Indian customer. Just an access which was granted to the Indian customer on the payment of a subscription fee, wherein nothing else is happening. Access is granted, Indian customer is putting its own data and getting the desired report. There was no right of commercial exploitation. The data which has been obtained by the Indian customer can be used by the Indian customer only. Customer's own data is put. Salesforce has no right on the data to keep the data in itself. No right was conferred on the Salesforce on the client's data. Salesforce owns all the right, title, interest in the IPR and the technology. These are quite simple things which is actually leading to one inference that this cannot form royalty. But no, let us not arrive at the conclusion straight away. There are other twists and turns as well, which are known as the distinguishing factors in every ruling. No right or license is granted to use any logo. Fine. Customers have no right to access the process. So there is no control on the entire infrastructure, on the entire equipment which is designed and created by the Salesforce, by the Indian customers. Okay, great. Now, what should be the other contentions of the revenue? It doesn't seem so easy to take the payment out of the royalty ambit, wherein at the first place or at prima facie it feels that it should come under the royalty because it's a result of a highly technically complicated driven technology based solution, which will ultimately benefit the Indian customer, which will ultimately be the source of the revenue or the source of income for the Indian customer. As per the UN commentary or as per the OECD commentary, if we see the information and how can it actually be brought to the tax, the term information is that the first criteria, it should result in the income for the recipient. Any information that you have received, it should result in your income. It should give you a direct benefit. Anyways, the interesting contentions of the revenue were in this, that basically the Salesforce Singapore entity is imparting information or a technical experience which results into a commercial expediency for the Indian customer at the end of the day. And that is why it should come under the royalty. Further, equipment is not under the control of the Indian customer as per the agreement, and factually also, because the data which was put in the CRM software ultimately gets stored on the server, and the location of the server or the situs of the server is important to determine the taxability. And the server is located outside India. There is no dispute on that. So two main points is whether if the equipment is not under the control of the Indian customer, okay, fine, it is not the royalty. But is it imparting a technical or commercial scientific experience by imparting information by the Salesforce to the Indian customer? If yes, then it's a royalty. If no, then it's not a royalty. Let's see. Coming to section 9(1) VI under the domestic tax law of India, there are several limbs under explanation 2 which defines royalty. Is like royalty means is a very important word to see here. Royalty means consideration for. Coming to the applicable limbs of this transaction is highlighted in bold, the imparting of any information, or another point, the use of process, or another point is imparting of any information concerning technically or scientific knowledge or experience. Experience is a very interesting word in this whole case law. Or the use of the right to use any industrial, commercial or scientific equipment, but not including the amounts referred to in 44BB. Fine. Coming to the article now, if it falls under 9(1) VI, then what the non-resident or a foreign company after that does, it goes to the treaty to basically get the treaty benefit which is conferred upon by the section 90 of the Indian Income Tax Act. It goes to the treaty. For example, a Salesforce thinks that it may fall under 9(1) VI. I'm not coming to a conclusion straight away. It will go to the Article 12 of the treaty because of the empowering section 90, which is given to the non-resident. The term royalties under Article 12 simply taxes the payment at 10%, wherein the royalty means a right to use a process or for information concerning industrial, commercial, or scientific experience. Again, identical words: industrial, commercial, scientific experience, process. These are all the relevant words for this particular case law. And how the interplay is going to happen, we are going to come in another 5 minutes. Point B, any industrial, commercial, scientific equipment consideration for the right to use of these equipments will fall under the royalty as per Article 12. That's what the plain reading actually implies towards. Coming to the decision of the Honorable Tribunal, because this is a tribunal ruling, assessing officer and CIT appeals held that this should fall under the royalty because it is imparting a technical, commercial, scientific experience to the Indian customer. Even though the equipment is not under the control, even though the Indian customer does not have access to the methodologies of the evolving databases, which is happening at the back end of the CRM software portal. Tribunal, very interesting. Sorry.
No, please go ahead.
Tribunal very interestingly appreciated the concept that it is a web access. No doubt, it is an access given on the internet. Internet is important to actually get the real-time reports. That is all fine. But whether it will qualify under royalty, we have to satisfy the imparting of information technological experience element in this entire transaction. There was one ruling of Thought Buzz, which is an advanced ruling which was relied upon by the revenue. Thoughtbuzz was a company which used to gather the data from all the third-party sources or the data which was already in the public domain. Thoughtbuzz didn't used to get the data from the client itself. Whereas in the Salesforce case law, it is my own data. It is the Indian customer's own data which is getting fed into the system. The revenue relied on AAR of Thoughtbuzz Limited, wherein it was held that these payments are going to be characterized as royalty and held taxable under a 9(1) VI or treaty, whichever is more beneficial. Accordingly, there were several other rulings as well, which was against the revenue and in the favor of the assessee consequently, wherein it was held that just because an access is granted, this does not mean a technical experience has been granted. For example, I go and buy a book. I can buy a book. It's a simple sale of a book by the bookseller to me, but the copyright of that book remains with the author. Similarly, in this case, ownership of the entire CRM, ownership of the entire architecture, the control of the equipment, control of the architecture is with the Salesforce. Point number one, not disputed. Coming to the technical experience, if the report which is getting generated gets fallen under technical experience, then it would be quite absurd, because the report which the person is getting at the end of the day is his own number, is his own entire statistics, which is just getting organized in a desired format, nothing else. No other value addition has been put in by the Salesforce which can help the client in analyzing the business data better. Had it been the case, this would have been covered under the royalty, but this was not the case in this ruling in hand. Further, there was no data centers in India. Servers were all located in India, so it will not be held under the article. It cannot be held taxable under the Article 7 also, since no profits, since there is no PE first, and no PE, then no taxability arises for the business profits, and no place of management. Similarly, going to the Article 7 immunity. Technical experience was elaborated much more in the supporting rulings in this particular case by the American Chemical Society and Dun & Bradstreet. There are cases which were cited in this ruling wherein it was categorically appreciated that Salesforce in this case is creating or maintaining the database. It is actually just processing your database. It is not doing anything else apart from these two activities. And the ultimate ownership of the data is with the client as per the master subscription agreement. It is not of the Salesforce. It is just maintaining the creating and maintaining and processing the data and transmitting it back to you in your desired format, and that too is not in the format which the Salesforce wants you to deliver. In the your format only, you're getting everything. You are feeding and you're getting what your own data in a desired format. That's it. There is no there was no sale of the IP which is owned by the Salesforce to the Indian customers. Hence, it should not get covered under the royalty. And further, in the case of American Chemicals, which was mentioned in this ruling, and Doon and Bradstreet, coming to the technical experience, it was very beautifully put. It is very beautifully put in that suppose a professor or a highly technical person is teaching someone, or is telling someone how to do something in this way, that statement by the, or that way of teaching it to someone how to do particular thing is a basis of the experience which that person has. That person cannot transfer his experience to you. In the case of American Chemical, what were the facts is that there was a portal which used to circulate all the research papers prepared by the renowned scientists from all over the world, and the American Chemical Society used to charge for that, and the consideration which the society used to charge could not get covered under the royalty, because this is not the experience which the American society was imparting to the public at large. This was the experience of the scientists which were getting imparted, and not of the American society. And similar analogy, if drawn to the Salesforce case, it is not imparting any technical experience. It is not imparting any knowledge of the methodology which they have actually employed to form or create their CRM databases. They are not imparting any information. They're not imparting any technical experience. They're not imparting any scientific experience to the client. It is just a normal information report, or a business data report, or a or any analytical report which will help the client the way and that would be helped only to the Indian customer only, not anyone else. It is, the report varies from person to person. So on all these lines, it was held that these services have an absent element of what? Imparting the information clearly, transfer of any knowledge clearly, or any experience or a skill. The person, for example, the engineer who has designed that CRM software portal has some empirical knowledge or a specialized knowledge. That knowledge is not getting passed on to the Indian customer at the end of the day. How can it be considered that a report, if the report has been generated, the entire IP or the entire methodologies of concerning these databases have been transferred? No, it would be absurd to say that. So it was held on these grounds, on these reasons, that this payment is not to be treated as royalty, both as per the domestic tax law and the DTAA. So this was it. In the interest of time, this is the ruling which was there, and it's a very commonly used ruling in the day-to-day transactions, wherein we get lots of invoices, we get lots of remittances of the similar nature happening day in and day out. Thank you so very much once again.
Explained this case law very well, and he brought out those finer nuances so very nicely. There were, in fact, I was just looking up, there were 2 or 3 more cases. One again is of Mumbai bench, Elsevier Information Systems GmbH. So that also again laid down the same law that payment for online subscription services will not be taxed as royalty. And there was one from Delhi bench. Let me just see. In fact, there was one in this, they had also referred to the AAR in the case of Dun and Bradstreet Espana.
Yeah.
And
Spanish
then there was another order of the IT18 ITO versus Cedilla Healthcare Limited. So maybe these were the maybe you can say the precursors, and then but they have not discussed human intervention in this order, have they?
No.
No, they haven't.
they haven't, sir.
So when I think I don't know
Very
whether,
beautifully written order. Very beautifully written order.
so I don't know whether Prakash made a comment that because of some judgments this law has come. Prakash, you would recall that it was the Supreme Court's judgment in the case of, I think, was it GSK or something, where they said on the domestic transfer pricing that there should be transfer pricing, and picking up from that, the government of India brought in transfer pricing legislation.
Yes, sir.
So
GlaxoSmithKline.
yeah, so I just think from memory, I think when you made that point, I think you'll find there are a lot of places where some observations, some comments, and the challenge, which I have seen is, I think it was late Justice Kapadia had made a point in one of the ITAT meetings which he was addressing. The difficulty, sir, is that he made a point that when you read the judgment, you read line by line and you start analyzing line by line, saying that the court in para 5 has said this, and para 7 has said this, and para 15 has said this, then there are contradictions. And his point was that don't read line by line. I think he said, look at the ratio of the judgment, because when you're writing a judgment, and sir, I'm sure you would probably have your thoughts to share on this. That when you're writing a judgment, you're not trying to see each line which is written. You're trying to look at what is the ratio coming out of the judgment and what is your final view on that matter. So I remember when the Morgan Stanley judgment came, it was, I think, more than 10 years back. It was analyzed by everyone, and everyone found fault with one line or the other. And I think which should not be the case. Look at the ratio, look at the principles, and the facts which are leading to a judgment. So I think the judgment has to be read in totality instead of reading a line and analyzing to create contradictions and create issues where none exist.
I have very important point on the Bombay High Court in the case of L&T judgment here. Before I come to this point here, in my humble understanding of the judgment here, the conclusion is correct, but the reasoning is not correct. With my humility here, why I am saying so? In this judgment, the emphasis has been done on the term in connection with. However, if we read the statute here, I am just reading the 44BB because I have done a lot of work on the 44BB. So I have just practically recall everything here. It says that notwithstanding anything to the contrary contained in 28 to 41 and section 43 to 43A, comma, in the case of an SSE, comma, being a non-resident. So the SSE should be a non-resident. The first cursor is that. After that said, engaged in the business of providing services. So the SSE should be engaged in the business of providing the services. We will discuss the term services, qua the FTS and royalty, something different that will come here. Or facility in connection with. So the term in connection with is linked with the services or facility. Or supplying plant and machinery on hire, used or to be used. So the moment will come to the second limb, which talks about the plant and machinery. It says on hire, used or to be used. The term in connection with is not there. So the term in connection with is not qua the plant and machinery, but it is qua the services or the facility. First point is that here. So the term, when the court is taking the issue of the higher charges of the barge, which is trying to cover as a plant and machinery. So the term in connection with is something irrelevant here. They should discuss used or to be used here. The second point which is there here, if we compare the 916 limb here, which is very much pertaining to, and 916 and 917 is very much important for the purpose of understanding the 44BB. 916 says, which C has raised the point here, for use or right to use any industrial, commercial or scientific equipment. It is the term which is equipment is there. The equipment can be commercial, scientific and industrial equipment, but not including the amount referred to in section 44BB. When we come to the section 44BB, it says that in the part 2, it is plant and machinery. It is not the equipment. And we come to the explanation. Explanation say plant includes ship, aircraft, vehicle, daily unit, scientific apparatus, and equipment. So only qua the equipment, only the 916 is valid, not for the other limb of the plant and machinery that is valid here. For the purpose of the said business here. Now, another part is that is very much interesting part is there. If we come to the 917, which talks about the FTS. FTS has an exclusion clause. FTS is an exclusion clause. It says that for the purpose of this section, clause fee for technical services means the consideration, including any lump sum consideration for rendering any managerial, technical, and consultancy services, including the provision of services of technical or other person, but does not include consideration for any construction. The moment you will say that construction is there, so the services can be in their construction. Construction will be go to the 44 triple B. Assembly is a different business itself. Mining. From here, the term mining, there is a Soli Sorabji opinion that the mining will include everything here. And 44 BB is qua the mining of the mineral oil, not the mining of the everything. So the mining is a very broad term. Mining of the coal, mining of the bauxite, mining of the anything can be covered under the 91 exclusion clause of the 917. Whereas the 916 in 44 BB talks about the services which may be the FTS, but qua the prospecting and the exploration of mineral oil, which is especially used for the purpose of the prospecting, exploration, and production of mineral oil, that will cover into the 44 BB. Another is important aspecting, very much important point is there. The 44 after 44 BB, there was in between 44 D. Between 2003 to 2011, the 44 D was under the sunset clause. From 1/4/2011, the 44 DA came into the picture here. And all the services which are not connected with the prospecting mineral or prospecting of this ones can be covered under the 44 DA, which is a general section where if you have the P, and naturally you have the P, that can be covered there. And also there is a net basis of taxation. The 44 BB is also net basis of taxation. So just 2 points that I wanted to draw with the permission of Mridhu ma'am.
So Mridhu, just one question to you. If you go to the chat box, there is a question put by Vijay Goyal. If you can just respond, and then we can go back again. So if you can just look at the chat, there's just before the end, where Yeeshu is thanking Aditi and each other. Just before that, there are 2 questions posted by Vijayji on your presentation. I think let's cover that first.
I can see use or right to use any commercial or scientific equipment and question mark there. And
prior to that, one I think prior to that or just after that. There are 2 questions together by Vijay, Mr. Vijay Goyal.
I can see how come control has been denied. No, so I'm able to see one.
Or can we allow Vijay Goyal to speak on this part here, and he can ask the question?
So the second question pertains to the next case law, Salesforce case law.
Okay, fine. So you can respond to your point, and then.
So sure. So I'm just trying to figure out what the question actually is. It just says use or right to use any commercial or scientific equipment question mark. Okay. So what my understanding is that again, what Prakash sir also brought into play was that there could be an ambiguity that could come in here, because the FTS clause very categorically takes out of or provides an exception for mining or like activities. Whereas under the provisions of royalty under the Act, there is no specific carve-out that has been provided to mining or extraction activities per se. It is only this particular subclause under the explanation 2, which and also again very particularly for the purpose of equipment, that there is a exception or there is a carve out. And in my opinion as well, that Supreme Court's judgment in the case of ONGC only spoke about FTS and services, because that particular case, all the agreements were only on account of certain services. There was nothing that was discussed on account of royalty. So given the interplay between 44BB and 44DA, even post the amendment that has come in 2011, which Sir has just spoken about, there could still be an issue where royalty, other than the equipment royalty, could still be a matter of litigation as to whether 44BB should apply or 44DA still, but would be an applicability here.
Sorry,
Again,
Mridhu, sorry interrupting you. Those questions are more on Salesforce, and I think I probably wrongly looked at the question.
Yes.
And that, yeah.
that's
Sorry,
all
so
right.
Yeeshu, please go ahead. You can respond, and then you can turn.
Mr.
Sorry.
Vijay is repeatedly saying, "This is for Yeeshu, please."
No, I saw that. I never wanted to interrupt.
My
Mridhu.
apologies. I just went on. I didn't
ma'am.
realize.
No,
No,
please,
ma'am,
please.
please. It just widened my perspective somewhere. So no need for an apology. So Vijay ji, thank you for your query. And if I go back to your question, you have two questions. One is on control, and you are saying that control is there on that part where the customer is able to upload the data and process the same, isn't it? Okay. And the second question is use or right to use any commercial or scientific equipment, question mark. So let me cover the concept of control. The control word is nowhere defined. If we go in the Oxford dictionary and find the meaning of control, is you will directly link it with the influence. So if you're actually able to influence the system, or you're actually able to influence someone in your daily life, you can be said to have been controlling that person. So if in this case, coming straight to the Salesforce case, it's a comprehensive CRM software which has been created by the Salesforce. There is no doubt on that. There's no control on the architecture. There's no control on the infrastructure. There is no control on the ownership. An Indian customer, for example, I get the subscription of the Salesforce for my business for whatever reports I want to create. I have to put in my numbers there. I cannot tell Salesforce that this is not the right way of doing this, or this is the right way of doing this, or this is not the right way of doing that, and vice versa. Even the Salesforce cannot tell me anything about it. So this is where the control comes into picture, that I am left with no choice. It is just that I am getting the subscription of the Salesforce to get the report according to the data which I am putting in. So there is no control on the back-end working of the Salesforce CRM portal. So that's where the control is coming here. If you are able to upload the data on the YouTube, for example, you make a video and you upload it on the YouTube and it is available to everyone, for example, it cannot be said to have that, it cannot be said to have that that you control the video uploading mechanism of the YouTube. You cannot, because you have been granted an access to upload by the YouTube. You have not created, or you cannot control. If you have not created anything, you cannot control anything, right? So this is where the answer to your query on control is there from its side. And another question is, I would come to that equipment thing. Usually, what would be the rate of Salesforce case if EL? Acha, Prakash sir has happened. What would be the fate or rate?
Fate here. If the equalization levy right now is applicable, whether the outcome of this case will be the same or it would have been different.
See, EL 2.0 is applicable, and it's already by Finance Act, the widen has already been, it has been widened. So certainly it can fall under the EL, because the concept of the EL was to actually, tax these kinds of transactions only, which gets immunity because of the absence of the PE, or they cannot not able to fall under the royalty or FTS. That is why there's a change in the budget which came in, which was the payment which could be characterized as royalty. EL 2.0 would not be applicable to them, and if it is not under the royalty, certainly it can go under the ambit of the EL 2.0 if it furnishes the requirements, it furnishes the conditions laid down in section 165A of the Indian Income Tax Act. Right, I will come to the question of the use or right to use any commercial or scientific equipment. So basically, see, equipment in this case is the entire technologically driven methodology, which is actually making your CRM software, live for the customers so that it can enable your customers to derive the reports out of it. If you want to elaborate, go more into the scientific equipments, then I would say there are variety of case laws wherein there are actually, there are actually names of the equipments which are mentioned in the case laws, which states that these are the scientific equipments, these are the commercial equipments, and these are the industrial equipments. For example, I remember there is a case law wherein medical equipments, just like thermometers or other complicated medical devices, they are treated as scientific equipments in that case law. I'm sorry, I'm not able to recall the name. I read it long time back somewhere. So it depends on case to case and facts to facts. I think the control can be viewed. Another question from the Vijayji is, I think control can be viewed in different ways. Here the control is that I'm able to work in that part license without anyone else having a right to deny me that access and use during the license period. See, again, you are using a service. You are confusing it with the control part. Control is somewhere that, you're influencing the system's algorithms. It is, you are just using a service which is given to you by the Salesforce. That's it, as per my understanding. If any other panelists would like to add to this, I'd be happy to hear that. But as per my understanding, you cannot confuse the grant of access to the control thing.
No.
I think
He's not confusing. He's just putting up some queries for the benefit of all the participants. Yeah. But you have hit the nail right on the head. So
thank you.
Thank you very much.
The example of uploading on YouTube was very perfect. Very perfect.
Thank you. Thank you, sir.